Right, good morning, everyone. Thank you for joining us this morning. I'm Mathias Cheung. Some of you might have seen me at one of our previous webinars before. Today, I have the pleasure of being joined by another member of Chambers. In fact, so I'm not doing this alone. We have Olivia Anderson, who is one of our more recent sort of additions to Chambers, and I'm glad that you can join both of us today. So over the next hour or so, we would be talking to you about the new JCT 2024 suite of contracts. Just to remind you all, this session is actually being recorded, so if you want to come back to this webinar at a later stage, or if you want to share it with your other colleagues who cannot join us this morning, then that will be available afterwards, and we will share the slides and the link after this webinar. If you have any questions as we go along the various topics, please feel free to put your questions into the Q&A box, and we will try and answer that in the sort of final bit of this webinar. So without any further ado, let's just make a start. So as all of you know, the JCT has released the sort of much anticipated suite of 2024 contracts. They haven't done so for all of the different forms of contracts within the JCT suite yet, but the main forms of contracts are actually out there already. So they've started with releasing the design and build contracts and also the minor works contracts to begin with, and also some of the subcontracts. And then in more recent weeks, they've released the intermediate contracts and also the standard building contracts. So we've now got quite a full set of these JCT contracts. And in fact, if you look at across all of them, of course, the numbering of the provisions might change, but the substance of a lot of these changes are actually quite similar. So what we will try to do, of course, over the next hour is not to go through each and every single one of these different forms of contracts, but to illustrate the sort of essence of these changes or the nature of these changes by looking at just the examples of the design and build contracts and also the minor works contract in particular. And they are quite representative of the changes that you find across the board. So we will focus in particular over the next hour on 10 topics. So I'll let Olivia kick off by telling you a bit about electronic communications, giving notices, and then the new provisions on good faith, collaboration, and also the changes, or perhaps maybe the lack thereof for some of you, in relation to building safety legislation and also things like ESG. Then I will sort of talk to you a little bit about what the JCT has done now on design liability in the design and build contracts, and then also on delay claims and also fluctuation claims and what they've done with those provisions. And then we'll wrap all of that up. Olivia and I will talk to you a little bit about the dispute resolution procedures and the termination provisions and what has or has not changed under those categories. So on that note, I'm going to hand over to Olivia to kick you off on the sort of first few topics.
Thank you, Mathias. I think we've got a problem there on the slides. And okay, great, thank you. So as Mathias said, I will be speaking first on the updates in relation to e-signatures and to electronic communications. The 2024 changes to the JCT are part of a modernisation drive, and these changes that I'm about to speak on are typical of that modernisation drive. They are more clarificatory than fundamental. They probably won't come as a surprise to anybody, but they work to helpfully clear up any doubts that may have existed in relation to these two areas. So first, e-signatures. It is commonplace, as probably everybody on this webinar knows, for parties these days to sign documents in counterpart and electronically over email by affixing an electronic signature to the PDF. That is obviously a departure from the traditional requirements for deeds of signing, sealing, and delivering the deed, or for a simple contract of applying a company seal or using a wetting director's signature. The 2024 JCT recognises this modern practice of electronic signatures in a new paragraph of guidance, which is under the heading Electronic Execution, which is on the attestation page. The new notes on execution confirms that e-signatures are valid as a form of execution on the basis of a Law Commission report in 2019 that itself concluded that an electronic signature is capable in law of being used to validly execute a document. So this new guidance in the JCT is a welcome clarification, and it clears up any doubts that may have existed on that matter. Although, as one slight aside, the JCT expressly does not endorse any particular platform or software for e-signatures, and that is left for the parties to decide themselves. Moving on to electronic communications. Again, this is a clarificatory update to the JCT. So in the 2016 design and build JCT contract, for example, any effective means was allowed for service of communications, and that was under clause 173. But there was one caveat to that, which is that the clause went on to say that such documents would be duly given or served if delivered by hand or prepaid post. Therefore, electronic notices were not expressly ruled out, and the clause coming before, clause 172, does actually or did refer to electronic transmission, but there were plenty of disputes about the validity of notices that were given electronically. As you can see on the slide, one helpful case is University of Brighton and Dove House. In that case, it was held that clause 173 contained a deeming provision rather than a restriction on the means of delivery that would be considered effective. So on the other side of the same coin, it was held in respect of clause 172, also in that case that the parties could agree to electronic service. There was a slight delta, and it was unclear what the position was when the parties had failed to agree to electronic service. But as explained, that electronic service had not been expressly ruled out by the terms of the contract either. Under the new JCT, that delta is somewhat addressed. There's a new provision, which is clause 1732 in the design and build and 1622 in the minor works. These provisions expressly allow parties to serve notices electronically by email. That is obviously a move away from the previous position, which only allowed for a postal address. There is a further new provision which is set out in clause 1742. That allows also, again, for electronic service where previously only hand delivery or first class signed for or special delivery would be allowed. But for that clause, the parties have to expressly opt in the contract particulars, and that can be significant because clause 174 relates to the notices given for default or termination. So that's something to watch out for when drafting, and to make sure the drafter expressly opts into it in the contract particulars if that's what the client requires. So that concludes the updates on electronic signatures and communications. So moving now on to good faith, which is every lawyer's favourite topic, or some lawyers. Yeah, some lawyers. The 2024 suite has introduced a new Article 3 into the Articles of Agreement regarding good faith and collaborative working. The new article is based on a previously optional supplemental provision that was in existence in the 2016 contract, but in the 2024 one, it's been given pride of place right underneath contract price, and it is a potentially significant new standard term. It provides expressly for a duty of good faith on the parties, and the wording is on the slide, which you can see, but really the key part of it is that the project team members, the parties, are to work with each other in a cooperative and collaborative manner in good faith and in a spirit of trust and respect. Again, as many people on this call probably know, good faith has not been, well, at least until recently, a concept that has gained much traction in English common law. When the courts have considered a wide or general obligation of good faith, which arguably this clause could be seen as constituting, whether or not that's express or implied, the courts have found that assigning a clear legal meaning to that term is challenging. Broad obligations of good faith are generally seen as often too vague to be enforceable. When the concept has been approved in the authorities, that approval has existed in the context of the court identifying a clear and relatively restricted meaning, often informed heavily by the facts of the case for that provision. But in any case, that's sort of general background to how we might approach good faith as a starting point. But in any case, this provision is very similar to the NEC contract clause 10.1. And so looking to NEC clause 10.1, that might assist in interpreting this new Article 3. There are lots of cases on interpreting 10.1, but a particularly useful one is noted on the slide. That's Costain and Tarmac Holdings. And in that case, Mr. Justice Coulson, as he then was, provided helpful guidance and observations on what good faith might mean under the NEC contract. In that case, he drew a parallel between the concept of mutual trust and cooperation on one side and pure obligations of good faith on the other. The court accepted that a duty of good faith like this one does not require parties to put aside self-interest, and it does not impose a fiduciary duty upon the parties in relation to each other. So this means that normal business behaviour is permitted if it's reasonable, but the court will consider whether a party has acted capriciously or unreasonably or unconscionably, and may have to consider a party's motive in so doing. A term of mutual trust and cooperation is similar, but it has been held to suggest that whilst parties can maintain their own legitimate commercial interests, they must behave so that their words and deeds are honest, fair, and reasonable, and not attempts to improperly exploit the other party. Again, this is very difficult to define more specifically. The concept of fairness is itself difficult because it's so subjective. But ultimately, Mr. Coulson in Costain accepted that the duty went further than a negative obligation not to do or say anything that might mislead, but it also extended to a positive obligation on the part of the defendant to correct a false assumption, in that case, that was obviously being made by the claimant. But again, such an obligation cannot require a party to set aside its own self-interest. There are these competing aspects to the concept which may have a sort of an inherent tension in relation to each other that is difficult to resolve, as Mr. Coulson wrestled with in Costain. So I'm sure that lots of further issues may arise or will arise in respect of this Article 3, but we're going to leave it here for now.
Yeah, no, I think we've, I mean, even when we were dealing with NEC contracts, when they had that clause 10.1, they've actually, I mean, we've actually seen that the court, I mean, they grapple with it, but they don't actually very much rely on it as a basis for decisions. I mean, some of you might have seen some of the Scottish decisions, for example, on the Van Ord case, for example, where they were dealing with omissions and whether omissions from a contract, omissions of works, amounted to a breach of the contract. And I mean, they relied a bit on the good faith, but that was more always a bit of an ancillary basis for the court to make a decision. So we might see, you're right, I think we might see some reasoning on it, but if you ask me, whether it would actually make any difference to sort of material difference to result. I mean, it would take quite an extreme case for that.
Yes, exactly. Yeah, exactly. I think it's often tacked on as a means by which a claimant can bolster their case rather than rather than forming the basis of a pure claim for breach.
Yeah, precisely.
Yeah. Right. Okay. So moving on to building safety legislation. The JCT has sought to accommodate the new building safety legislation in part. And in particular here, we're talking about legislation arising out of the 2017 Grenfell tragedy. The JCT attempts to deal with this legislation in a limited way, but nonetheless in an important way. In particular, the JCT 2024 seeks to address the new duty holder requirements that appear under Part 2A of the Building Regulations 2010. And this is slightly involved, but just to set out the statutory sort of trail that gets us there. Part 2A of the Building Regulations was introduced by the Building Regulations Amendment England Regulations 2023, and that itself was pursuant to the Building Safety Act 2022. So that's a sort of breadcrumbs of what the JCT is wrestling with. Part 2A sets out a framework of safety duties and competence requirements for persons involved in the procurement, design, and undertaking of building work to which building regulations apply. And this includes higher risk building work for which additional duties apply. There are new duty holders who owe statutory duties as a result of these regulatory changes. So the JCT seeks to wrestle with this primarily by introducing a new Article 7 in the design and build contract and a new Article 6 in the minor works contract. These articles both require the parties to specify who their principal designer or principal contractor is for the purposes of the building regulations. Those named principals would owe the relevant duties under Part 2A of the building regulations in relation to ensuring compliance with relevant building regulation requirements. To bolster that change, there's a connected change in the new design and build contract, which is at clause 316, and in the minor works contract at clause 29. Each of those additional clauses contain an undertaking by each party to comply with Part 2A of the building regulations. That is a new undertaking, and it is in addition to the usual obligations which arise from the CDM regulations, which one finds in the previous suite of contracts. This undertaking could potentially be helpful in forming the basis for a claim of breach or for potential breach in the event of a dispute about defects which arise from, for example, non-compliance with the building regulations. But these changes have been criticised for not materially grappling with or expressly setting out the specific requirements for higher risk buildings. And that is a mission that the changes have been, has been particularly criticised in respect of the changes. So it has left the parties to institute bespoke amendments or to consider whether the contract should deal with the higher risk requirements and whether or not they want those requirements to be set out more comprehensively in the JCT. The JCT 2024 also has made changes in respect of ESG, which is obviously an important part of many companies' internal values and policies. Again, this is part of a story of modernisation that the 2024 JCT has sought to reflect. Again, the changes are not sweeping, they're not revolutionary, but they're incremental and certainly a step in the right direction. Really, though, they address the E rather than the S and G. In the main, the changes have moved optional supplemental provisions on ESG from the JCT 2016 into the main conditions of the 2024 contract. So, for example, in the JCT Design and Build 2024, clause 215 expressly encourages contractors to suggest economically viable solutions to the works which may result in an improvement in environmental performance and sustainability and a reduction in environmental impact. This is a helpful express encouragement to come up with environmentally friendly design solutions, but it has to be said, it's not an obligation, it's not an undertaking, and neither is it a warranty. It is simply an encouragement. So we can query how effective this provision might be when it comes to enforcement or any potential claim. What does an encouragement really mean, and how can it be demonstrated on the facts? What degree of encouragement is the appropriate level of encouragement? So with that query in mind, maybe that's helped by clause 222, and that's in the design and build contract, or clause 213 in the minor works contract, which might give the earlier clauses a bit more teeth. These new clauses expressly require the contractor to provide all the information reasonably requested by the employer regarding environmental impact of supply and use of materials or goods selected. So this might give the contractor some further encouragement to ensure that what they have selected in the way of materials or design solution, that they can satisfy the employer and themselves in due course of the environmental impact. But again, these provisions really are light touch compared to the NEC option X29, which is significantly more onerous and includes climate change requirements, a performance table, among other things. And it's left to the parties if they want to make these ESG provisions in the JCT more far-reaching, and if they want to make bespoke amendments that reflect their own internal policies. That's something that they should give some thought to, because these standard terms might not get them there, depending on their level of internal concern. And that concludes the first 4 issues, and now I can hand over to Mathias.
Thanks, Olivia. So the next topic will probably be closer to home to those of you who are more sort of used to dealing with design and build contracts and having to grapple with design obligations under a building contract. So some of you would recall, or actually may not just recall, but actually have come across problems in your actual projects where you have competing design obligations under the contract, and so you might have one sort of general standard for reasonable skill and care, which is, if not expressed and certainly implied in most of these contracts, and then you might have a slightly higher standard of care or higher design standards somewhere in the specifications, maybe an employer's requirements, for example, and so then you end up with sort of 2 sets of standards, and you're not sure which standard you're held to if you're a contractor. So that obviously is the sort of type of scenario which the courts have grappled with in the anti-Hogarth case, for example, just a couple of years ago, and that went all the way to the Supreme Court. So that just tells you how contentious those sorts of issues can be. I mean, in that particular case, what happened was that the employer obviously had in the main conditions of the contract a general duty of skill and care imposed on the contractor, but also when you look at the employer's requirements, there are particular standards which are, industry standards which the contractor had to comply with, but the compliance with those standards somehow didn't actually enable the contractor to ensure that they meet the design life requirements or the fitness for purpose requirements, which are also somewhere buried deep in the employer's requirements. So you end up in that sort of situation every now and then. And what the design and build contracts has done, for example, is that they've introduced a new clause 2.17.1.2, which says that irrespective of what's in the contract, and to the extent that this is permitted by the statutory regulations, so building regs, for example, the contractor doesn't actually owe any particular standard which is higher than the standard of skill and care. So to make it clear, they don't owe an obligation to warrant that the design would be fit for purpose, because that actually, if you have that sort of warranty, that is obviously a strict liability. So it's either fit or unfit. It's not so much a question of whether they've exercised care or not. So that is the standard provision in the JCT at the moment. In a sense, that's obviously quite friendly to contractors. For employers who actually thinks that, oh, well, hang on a minute, I want the contractor to warrant that they will comply with particular standards, then they have to be quite careful, because that means that almost certainly you need to think about the new JCT 2024 clause that we've looked at. It also exists in other contracts in the suite. So if you look at the JCT minor works contracts with contractors design, you can find a similar provision in clause 2.1.3.2. And if you're an employer thinking that, well, I don't want the contractor only to owe a duty of reasonable skill and care, then you would have to probably amend this clause, or at least make some sort of adjustments to make it clear that the contractor has to both owe a duty of care as a minimum standard, but also some of the higher standards which are expressly required in the employer's requirements. So something to be quite careful about if you're dealing with a design and build contract. So just moving on now from design and build contracts and liability, we're looking more now at delay claims, which, again, another sort of favorite topic of many a construction lawyer and indeed construction expert. So the JCT has introduced a few changes. I wouldn't say that they are necessarily very dramatic or sweeping changes, but they are nonetheless quite important to note. So when you look at the JCT design and build contracts, for example, you would see that they've actually introduced a few new relevant events and relevant matters. So relevant events for extensions of time claims, and then relevant matters relatedly for loss of expense claims. And you can see on the screen that, I mean, none of this would come as a particular surprise to any of us, I think, because if you look at the new relevant matters and the relevant events, so the first 2 of them, so if you look at the new clause 2.26.7 and clause 2.26.8.3, they actually almost certainly have in mind what everyone has gone through back in 2020 and 2021 when the COVID pandemic broke out. So clause 2.26.7, that is a clause which deals with EOTs for an epidemic, which occurs after the base date. So obviously important to bear in mind, it's not just any epidemic which has happened, but something which occurs after the base date. Or if it's before the base date, then it has to, the effect of it has to have changed sufficiently in order for it to be an extension of time. So there's probably a question of, okay, well, was it foreseeable? Was the effects foreseeable? As some of you can remember back in the days, there were all of these sort of questions of, okay, well, if we were looking at this simply from the through the lens of the force majeure clause, for example, does it cease being foreseeable and cease being a force majeure simply because the pandemic has rolled on a little bit for a few years? So that's what clause 2.26.7 is trying to make clear. So you've got epidemic as an express basis for an EOT and also for a loss and expense claim. Relatedly, the second clause, so 2.26.8.3, so normally we're dealing with sort of change of law and change of statutory requirements after the base date, but now what is actually also been introduced is that in addition to a change of law strictly, you can also have a change in, for instance, government guidance, and also not just guidance from the government or public authority, in fact, but also guidance from the Construction Leadership Council. So again, very clearly for those of you who still remember what sort of guidance has come out during the COVID period, this obviously has in mind the particular guidance, so let's say from Public Health England at the time, in relation to working safely in the workplace. So that sort of guidance, and also the Construction Leadership Council had their sort of site protocol or site operation protocol for dealing with COVID and sort of keeping sort of working safely, keeping a safe distance and social distancing on site. So that sort of guidance, which is technically not law but soft law in a way, that has also become now an express basis for potentially claiming an EOT and loss and expense. So quite a helpful thing to have. Well, I mean, obviously none of us hope that COVID or something similar to COVID would happen again, but just in case, you can never be too safe in any sort of aspects of life. So we have those provisions now. The last sort of new relevant event or relevant matter deals with something quite different. So if you look at 2.26.4 and 4.21.3 of the new JCT design and build contracts, that deals with instructions from the employer to deal with things like asbestos, contaminated materials, and unexploded ordnance. So basically dealing with unforeseeable conditions inside where you've, for instance, dug up contaminated materials or an unexploded sort of bomb from the World War II, for example. So those sorts of things are also now expressly provided as a potential ground for getting an EOT and also loss and expense. I should say that as important to bear in mind, it's not just any asbestos or any contaminated material, for example, on site, because there are obviously cases where those sorts of things are foreseen. And so, for example, you have some contracts where the contractor would have to go in and do a sort of pre-construction sort of contamination study or survey just to investigate the extent of any asbestos or contamination. So in those circumstances where the contract has actually identified a particular risk of the presence of such materials, then that would obviously take that outside of the scope of these EOT and loss and expense provisions, subject to the facts of each case. So something to bear in mind. But those are the new grounds introduced by the JCT suite. Now, looking at more at the procedure for making an EOT claim, so that hasn't really changed that much. But there are two sort of small exceptions to that. So the new JCT suite and the design and build contract, for example, if you look at 2.24.4, that actually now provides for a particular defined period for the employer to request further information after they've received an EOT claim. So previously, some of you would recall, the employer can actually request further information at any time. So gives the employer almost a carte blanche to just keep requesting further information, and then that just sort of pushes the determination down the line. But then now there is a fixed period. So that's particularly important for employers to bear in mind, because then it really sort of focuses the mind of the employer and the contract administrator. So if once you receive the EOT claim, you have to think about, okay, what further particulars you request, and do that within the 14-day period. The other bit also relates to employers. It seems like a lot of this is actually more geared towards the procedure that the employer has to adopt rather than what the contractor does. And that's clause 2.25.2 if you look at the design and build, the new design and build contract. And that basically requires the employer to notify a decision on an EOT claim within a shorter period. So previously you have 12 weeks, now you only have 8 weeks. So that's 4 weeks sort of shaved off the previous period allowed to the employer. So it seems like it's just trying to put pressure on the employer to make a quicker determination, which I think sometimes it's, probably possible, sometimes maybe not so, but this is something to just remember. I mean, obviously, if the employer provides a decision a bit later, I don't think that necessarily actually moves the dial very much, in the sense that it doesn't probably bar the employer from arguing something else later on if an adjudication happens. But I think it just gives a bit of an aspirational timetable where the parties can actually deal with EOT claims more quickly. And if that decision isn't received, let's say within 8 weeks, for example, then there would probably be a crystallized dispute, and one might expect an adjudication to be commenced on that basis, whereas previously they might have to wait a bit longer. So that's just something to remember in terms of procedure. I would just make sort of one little sort of side note, which is not on the slide as well. So some of you might be aware that there is a recent Scottish sort of outer house decision related to the conditions precedents, or whether one of these notice requirements for a loss and expense claim actually amounts to condition precedents, and that is the FES decision. So obviously the JCT contract suites came out already sort of around the summertime, so that didn't actually take into account this very recent decision from the outer house. But what the outer house has decided, after looking at a lot of English case law, is that when you look at clause 4.20 and clause 4.21 under the loss and expense provisions, those notice requirements actually do amount to a condition precedent, because the entitlement to claim loss and expense under clause 4.20 is subject to compliance to the notice requirements, and that's the express wording used, and that's sufficient to give rise to a time bar. So something to remember, because that would be quite persuasive, I imagine, in an adjudication or in a TCC dispute in England and Wales. So if that's not the position that you would want as a contractor, for example, then that is something that you might want to look at amending, and that not something that you can rely on the JCT 2024 suite to do for you automatically. So that's on the sort of EOT loss and expense side. So we're talking about contractors' claims. Moving now to the other side of the same coin, so liquidated damages. Really nothing really fundamental, I would say, introduced by the JCT 2024 suites. For those of you who are familiar with the triple point decision from the Supreme Court back in 2021, and I say those of you, I mean all of you are familiar with that, no doubt. We all know now, of course, that the default position is that liquidated damages are enforceable irrespective of termination, of course. So if you have termination before completion actually being achieved on a project, the liquidated damages clause would typically just run all the way up to the point of termination, and then after termination, you will still have a claim for general damages for delay and breach of contract. So that's the orthodox position, and what the JCT has done is to just legislate expressly for that orthodox position. So if you look at the design and build contracts, for example, you will see 2.29.5.1 and 2.29.5.2. And what those two provisions try to do is essentially to say, well, LDs run up to the date of termination, if there is a termination. And then after termination, nothing in the provisions in the JCT prejudices or precludes the employer's rights and remedies in common law. So general damages, as I've said just now, which is what Triple Point has decided. And you'll find it also in the other sort of parts of the JCT 2024 suite. So in the minor works contract, you will find that position again expressly provided for in 2.8.4. So just again, if you're an employer or you're a contractor and you think, okay, well, I don't actually like that position for whatever reason, I don't imagine that actually happens very much. But for instance, if you're a contractor and you actually want to provide for a position where upon termination, liquidated damages somehow evaporates, you would actually have to legislate for that. And I think you would have to do that anyway under the triple point decision. But with these express provisions in the JCT, there's just no room whatsoever for arguing that the construction is different from what triple point has considered in that particular case. So something to remember for those of you who want to make bespoke amendments to the LD's position. Finally, then, just very briefly on fluctuation claims. So this is actually sort of in some ways linked to delay claims as well. But obviously, fluctuation is sort of an issue in its own right. So you will recall that in previous JCT suites of contracts, you will have an option for fluctuation. So you have a sort of optional fluctuation clauses provided within the main body of the contract. Now, I'm not sure, so I'm not going to do a straw poll now because it's remote, but I think if I did do a straw poll, or a notional one at least, I think it would be fair to say that there would be very, very few of you in the room who would actually have opted into the fluctuation options in many of these contracts. So I think how much it's been used, I think all of us would probably have a fair idea how sort of popular or unpopular these sort of options are. So what the JCT has decided in the 2024 suite is that, well, since these options are probably not very much used, and more often than not, you just have parties basically striking out these clauses or opting out of them in the contract particulars and putting a line through it. Sometimes they might have forgotten because, you know, they've just gone through the contract particulars and thought, you know, they've just assumed that these options don't normally apply, and then they've forgotten to strike it out. And then there's a sort of dispute about, oh, well, do they actually apply or not? So doing away with all of that, what the JCT has done is that they've just taken out all of those optional fluctuation provisions and they've just put it on the website. So, you know, for those of you who actually want a fluctuation provision, it's still there, but it's no longer in the standard form that you would adopt in the main body. So if you want a fluctuation provision, I think to be fair, I think the best thing to do is really just to negotiate a bespoke provision or bespoke amendments to the JCT contracts, because the JCT optional provisions themselves are probably not sufficient to deal with the sort of situation or all the situations that parties would actually want to cater for in any event. So I think in particular after COVID-19, what I've seen is that in a lot of cross-border contracts and indeed in a lot of domestic projects, fluctuation is a bit of a problem, particularly where you're dealing with sort of material prices, you know, fluctuating, and also inflation due to, you know, things like the Ukrainian conflict, for example. So those sorts of issues are actually quite topical. They're not dealt with by JCT in any way material, other than, you know, taking out fluctuation provisions. So those would have to be dealt with by bespoke amendments, I'm afraid. But one thing to bear in mind is that if you don't make any amendments to the JCT standard provisions in the 2024 suite, there is still potentially some scope, I would say, for fluctuation loss relating to delay, for example. And this is the same position as in previous suites, in the previous suites. So if you have a delay claim and somehow the delay has also meant that there are fluctuation or inflationary losses, you might be able to actually include that as part of a loss and expense claim if you can show that it's directly incurred loss and expense. So the JCT terms do not have and have never actually precluded those claims, and that is still an option. Now, whether that actually flies in a particular case, I think that also depends on the facts. But that really is still the state of play at the moment on the JCT terms. So that's all I want to talk to you about delay claims. So I'll just hand over to Olivia very briefly now to talk to you about the dispute resolution procedure that has changed slightly under the new JCT suites.
Thank you. The JCT, I mean, Mathias is right, has only changed slightly. The 2024 contract hasn't done much to replace or amend the existing provisions relating to the negotiation of disputes. There is one slightly more significant change, which is the introduction of a standard clause in both the design and build and minor works contracts that requires parties to promptly notify a dispute and then have their relevant executives meet as soon as practicable to negotiate in good faith to resolve the matter. So first and foremost, again, it includes a good faith element, which I will return to in a moment. But this provision was present in the previous suite, but only as an optional supplemental provision. Whereas now, as I've said, negotiations are expressly encouraged. So that can work against parties who traditionally seek to rely on the black letter of the JCT and tend to be reluctant to display flexibility when it comes to events that are not contemplated by the terms of the contract. This provision can be seen as pushing them to respond in real time to things that in a way that might not have been expressly contemplated by the contract. The provision is expressly subject to the party's right in Article 8 to refer a dispute to adjudication at any time, but it is not clear whether the negotiation requirement is a condition precedent to litigation or arbitration. It should also be noted that the provision is quite simplistic. It obliges the parties to negotiate, but there is no procedure for those negotiations set out. Neither is there a time frame within which they need to be concluded or to have been attempted but failed to have yielded any success. So therefore, enforcement of the clause might become a complex issue. There are three key cases that might help us to think about enforcement of the clause, which are all put on the slide. And the starting point is Wolford and Miles, which is a 1992 decision where an agreement to negotiate for an unspecified period of time was held to not be enforceable. And the reason given by Lord Ackner in that case was that in those circumstances, and particularly in that case, the vendor would not be obliged to conclude a contract and would therefore not know when he was entitled to withdraw from the negotiations. And therefore, the courts couldn't be expected to decide subjectively whether a proper reason for ending negotiations existed. And on that basis, the provision was unenforceable. But then, on the other hand, in Emirates Trading, which is slightly more recent, a dispute resolution clause in a contract which required the parties to seek to resolve a dispute by friendly discussions in good faith and within a limited period of time before the dispute could be referred to arbitration was enforced. In that case, it's notable that there was a 4-week period that was expressly set out and required. But then again, last year, the Court of Appeal refused to enforce a dispute resolution procedure that appeared in the contract in Kashmir Construction Europe on the basis that the process was too uncertain. And again, there was no timeframe or procedure set out. So really, the recurring theme here seems to be the clause should have, or we want, ideally, the clause to have a timeframe for negotiations to take place within. There is therefore an open question about the enforceability of this new clause 9.1 in the DB and 7.1 in the minor works, about the enforceability of those clauses. There is a possibility that if a party commences litigation or arbitration without first negotiating the matter, there could be an argument from the opposite party that there was a failure to comply with the dispute resolution procedure, so that at least a stay should be imposed on proceedings. But that would really depend on the facts of the case and how the clause is interpreted. So that's an open question to think about going forward.
Thanks, Olivia. Yeah, I mean, I must say, I mean, from personal experience, I think these dispute resolution procedures, I mean, is all sort of well and good in theory, but most of the time, when you sort of have the sort of multi-tier, sort of the cascade of different processes, parties just try to jump through the hoops without actually really thinking about talking to each other, and then they just go through adjudication anyway. So, I mean, it adds another layer of hurdles that they need to jump through, but more often than not, I think whether sort of failure to negotiate itself would actually give rise to a problem and prevent sort of an adjudication or litigation. I mean, I certainly don't think, I mean, looking at the JCT wording, I mean, that's probably falls a bit short of the sort of procedure that you would expect in order to achieve that result. And I mean, in any event, I think that's something which parties can quite easily discharge if they just talk to each other. So yeah, I mean, it's one of those things, I suppose, where if parties actually want to do want a pretty rigid sort of multi-tier or tiered dispute resolution procedure, then I think they might just have to amend the JCT again anyway, irrespective of the standard amendments. But there we are. I mean, most of these, I think, are probably just there just to encourage parties to talk in good faith. But I suppose where parties don't actually manage to resolve the dispute or talk in good faith, then one of the results that might happen is termination, which is the last topic I would want to cover this morning. And termination, obviously, in recent times in particular, has actually happened quite a lot. For various reasons, because of cash flow or because of defaults under the contract. So I think two important amendments to remember from the JCT 2024 suites. The first one is actually in relation to termination for insolvency. So, I mean, definition of insolvency, as you would all know, is already quite sort of detailedly defined in the current sort of existing or previous suites of JCT contracts. What the JCT 2024 has done is that they've expanded the definition of insolvency. So, for example, if you look at the design and build contracts, and you look at clause 8.1.4, and also if you look at the minor works contract, that would be now clause 6.1, you would see that under the definitions, they've actually included further examples or events of insolvency, and that's to take into account sort of more recent legislation introducing further forms of insolvency events which fall short of an administration or liquidation or something like that. So, for example, you would now have something like a moratorium under Part 1A of the Insolvency Act. That would actually be an insolvency event now, and also a compromise or an arrangement under Part 26A of the Companies Act. That too would also count as an insolvency event. So even if a company has fallen short of going into full-blown liquidation or administration, where there is a moratorium or some sort of arrangement compromise with creditors, that could also still give rise to a ground for termination. And now, if the parties actually don't want that in the termination provisions, then again, that would have to be specifically sort of amended or omitted. So that's the grounds for termination for insolvency, where the other change actually relates to something different, which is the sort of procedure for termination payments. So some of you might recall from a couple of years ago now, actually more than a couple of years ago now, it's like 7 years ago, that's the Court of Appeal decision of Adam Architecture and Holsbury Home. So that's quite a well-known decision of the Court of Appeal. And what the Court of Appeal decided in that case basically was that in the event of termination, nonetheless, the payments which falls, the final payment which sort of happens after termination, or in that scenario, that would still attract the sort of payment procedure and the sort of due date and final dates for payments, and that sort of time scale for making a payment in that event. And so those procedures actually don't just apply to a situation where you have a sort of, for example, interim payments or just a final account payment. So what the JCT has done now is to say that, yes, that is indeed the position. So rather than just leaving that to case law and the scheme for construction contracts, for example, which gives you all the default provisions, the design build contracts, for example, if you look at clause 8.13, and if you look at also the minor works contract, which has a similar clause 6.12, that actually now expressly legislates for a sort of payment timetable for the final payments in the event of a termination. So there is now a due date, final date for payment, and the deadlines for payments for a payment notice and payless notice expressly legislated for in the contracts for termination payments. And that is also there to comply with the Construction Act, obviously, in the light of the Adam Architecture decision. So that is something to bear in mind. And actually, I think that is quite helpful to the parties because it just puts the position beyond doubt. Again, it also means that if the parties want something different in terms of the timescales for termination payments, so sometimes you might actually need a bit more time to think about termination payments and when they fall due, and for that payment to be payable, then bespoke amendments would again have to be introduced. I should say, in any event, if you look at the termination provisions, there is actually quite a sort of significant time frame in any event for the contractor to provide all the information to the contract administrator for consideration, and then for that to actually come up to a statement of account between the parties in any event. So that actually hasn't been moved very much. And so if the parties want something different, that is something to think about when you think about what amendments you would want to make to the JCT provisions. So I would just want to end on not so much an amendment to the JCT suites of contracts, but actually on a bit of case law, because a lot of you have actually come across this case, no doubt, already. In fact, I've got a question in the Q&A, I believe, on this particular case, and that's the Providence and Hexagon decision of the Court of Appeal just a few months ago. Now, for those of you who haven't actually come across this case before, this case actually deals not so much with the provisions which I've just touched on a moment ago, but actually on the notice provisions. So what sort of notices you need to give in order to terminate the contract in the event of a repetition of a specified default. So briefly what happened, and I should say this case actually dealt with not the JCT 2024 suite of contracts, obviously, but the JCT 2016 contract. But nonetheless, because the provisions haven't changed and the wording is still substantially the same, this case actually applies equally to the JCT 2024 contract going forward. So what happened in that case was that back in 2022, there was a payment default by the employer, so they failed to pay the certified sum by the final date for payment. A default notice was served, so that would give rise to a cure period, obviously. But then within that sort of 28-day cure period, the payment was made. So the default was cured. no basis for serving a termination notice for that reason. But then you fast forward almost a year to 2023, and then there was another failure to make a payment under a different payment notice. And this time, the specified this was a sort of repetition of a specified default, or at least that was what Providence said. So they gave notice that this was a repetition of a specified default, that being a failure to pay a certified sum, and therefore the contract was terminated under clause 8.9.4, which allows a termination to occur immediately by giving that notice where there is a repetition of a specified default, and that almost allows you to bypass the requirement to normally serve a default notice first before you serve a termination notice. That was challenged in an adjudication and then in TCC on both occasions. Hexagon succeeded in saying that the termination was invalid because previously the default was cured, and so that, they say, didn't give rise to a right to terminate under 8.9.4. The Court of Appeal then actually reversed the TCC's decision. So they said that actually, no, there was indeed a right to terminate for a repetition of a specified default. And the basis of it was really, very much focused on the wording of the provisions. So one of the questions that I've seen in the Q&A already is that, well, has the Court of Appeal actually not focus very much on the practicality of the financial position of the parties, and also the cash flow position, for example, of the parties. So from the employer's perspective, in fact, one might say that, well, this is quite unfair because, for instance, for an employer, they might be having, it's usual to have cash flow issues sometimes. So one might actually have payment failures every now and then. So as long as they've cured that payment default in the first place, then it's a bit unfair that if they fail to pay again, but on a different payment notice, a different default, so to speak, that somehow gives rise to another sort of repeated default, and therefore gives rise to an automatic right to termination. So one might say that from a commercial common sense point of view, that doesn't actually really accord to the employer's commercial common sense. But I think what the Court of Appeal actually did was that they actually said, well, because this is one of those clauses where if you look at it from the lenses of the different parties, each side would have their own view of what business common sense is. So the contractor would say, well, no, I have to protect my cash flow. So that is why once you repeat a payment default, I should be entitled to terminate immediately. On the employer side, no. It's just a one-off, or maybe a two-off in this case, I suppose. And I shouldn't be terminated just so quickly or so easily. So because there are arguments on both sides, what the Court of Appeal said was, okay, it's difficult to decide based on just business common sense or cash flow concerns. So they're going to focus very much on the meaning of the words and the language used by the parties. And I think, to be fair to the courts, if you look at the wording itself, it actually doesn't really help the argument that you can't have a repeated specified default as long as it's actually cured in the previous occasion. So if you look at 8.9.4 itself, it allows that further notice of termination to be served if a notice hasn't been served on the previous occasion for any reason. So when it says for any reason, I think it actually means for any reason. And, that's sort of, just natural and ordinary meaning of the words, quite like, what we've seen since, the Supreme Court gave their decision back in, 2015 in Arnold Britain, same approach. If that's what the parties legislated for, it's not for the court to actually gainsay that or to change that for the parties. And that's broad enough to cover any reason, including where the notice previously wasn't given on the previous default because it's been cured. That's also covered by the words for any reason. And I think it's also important to bear in mind that when you look at these clauses, not just looking at clause 8.9, but also looking at clause 8.4 as well. So clause 8.4, again, hasn't been changed in the JCT 2024 suite. That deals with contractor's default rather than employer's default. But what the court said is, well, both of them are structurally quite similar, so they must be considered in sort of holistically and also construed in a consistent manner. So if one looks at clause 8.4, for example, dealing with an a contractor's default, that actually also says that where there's a repeat of a specified default, you can terminate, and that applies in the case where a notice hasn't been served on the previous occasion, whether as a result of the ending of any specified defaults or otherwise. So that is actually quite even more express than the words for any reason, but that applies to contractors' default. For that reason, they think that 8.9 is also intended to have a similar meaning, even though it's worded slightly differently. So just by looking at the wording, and because common sense doesn't really help, as I've said just now, that is the meaning of the JCT standard form, unfortunately, as it's drafted. That hasn't changed at all in the 2024 suite, as I've said. So if the parties are, a bit concerned or irked by the recent court appeal decision, and they think, okay, well, I need to protect cash flow one way or the other for one or the other party, then these provisions certainly merit looking at again and making certain bespoke amendments, because, as I've said, the decision has been made by the court appeal. I don't think it's being appealed further, at least not for now. So that is the current state of the law. So if you're relying on the 2024 suite, this is one of the problems which you might have to fix for yourself, so it's a self-help problem rather than a JCT 2024 amendment fix. So on that note, I think we've covered everything, at least the key changes that I think I want to draw to your attention this morning in relation to the 2024 suite. So we have a couple of more minutes, so let's have a look at the Q&A, shall we? So what have we got? We've got quite a few, in fact, so that's great. So first one, I think, is it's a question relating to the BSA, and the question in particular is, do we anticipate that there may be an amendment similar to the CDM amendments back in the days to the 2010 suite once the dust has settled on higher risk buildings? I'm not sure what you think, Olivia. I mean, I probably have my my view or guess. Probably is the better word. What is your guess?
I haven't seen anything as yet to suggest that an amendment is coming, so I don't know. But perhaps. But it feels to me. I mean, I'm interested actually, Mathias, in what you think. But to me, it feels like the emissions to do with the high risk buildings feels quite deliberate. Or how could they not have noticed when they were doing the updates? I'm not sure. I'm not sure.
Yeah, well, I mean, it's one of those questions where I think it's like looking into a crystal ball, but we don't have a crystal ball. But yeah, no, you're quite right, Olivia. I think that's also my impression, because the Building Safety Act has come into force since 2022, June 2022. Obviously, there have been building regulations changes to implement some of these statutory changes under the BSA. So some of those regulations came a bit later. So for instance, we've looked at the building regulations amendments from 2023, for example, but I think I agree. I mean, none of them are particularly new in the sense that they were either unexpected or hasn't been discussed already a lot before the enactment of these sort of regulations. And indeed, before the 2024 suites have been rolled out, there's still been a full year in between, almost at the very least, or 2 years, in fact, for looking at all of these different changes as they rolled out. I mean, there is an argument for saying that, okay, well, it's still quite new. So, I mean, that is true. But I also get the feeling, sort of anecdotally speaking to people who have been involved in the deliberations for the new JCT 2024 suite, that they haven't dealt with it because it's just a bit too difficult. And different projects may have different needs as well, because you might have some buildings which are high risk buildings, some of which might not. So the view taken was that they would just keep their powder dry and hold fire on that. So I think it's possible. I wouldn't rule that out. But also, I think part of me sort of feels that I think that what the JCT is thinking is that, well, let's see what parties actually do or want in their bespoke amendments to the JCT agreements, because we've already seen some of these bespoke amendments being made. There's also an argument saying that, well, actually, you know what, these are all in the statutory provisions anyway, so the parties have to comply with statutory requirements. There is always the requirement generally in the JCT anyway to comply with that. So let's just let the parties decide what they need or need not do. But I personally think that, and that's going on to perhaps a different question which is raised in the Q&A, there's a question of whether it is actually helpful for the parties to set out in full these obligations in relation to the building regulations in amendments in a standard form contract. And are we in favor of that? I think probably saying whether we're in favor or not is putting it quite strongly. But I would say that it's one of those things which, again, very much depends on what are the needs on the contract. So if you are dealing with a project which involves a higher risk building, I mean, I'm not sure about you, Olivia, but I mean, personally, I think it would at least merit a decent conversation in the sort of tender stage, in the bidding stage between the parties about, okay, well, what do we actually need to do? Now, whether that goes into the contract or not probably depends on the circumstances, because sometimes you might have a contractor who is engaged to do sort of pre-construction services, and that early sort of tender design stage, they might already have to jump through all the hurdles, and by the time you actually sign the design and build contract or whatever, you might actually have already done most of the stages in relation to the higher risk buildings for the gateway applications, for example, through the building safety regulator. But so it depends on the circumstances. But I think if you are embarking on a design and build contract, for example, and you are expected to go through the building safety regulators process, then I think you need to at least look carefully at the JCT provisions and see, okay, well, does that work within the time frame? So for example, within the program, have you built enough time for that process, for the design process? Because that actually itself can take quite long, whether you've made that application or not. And if you actually haven't made that application yet, and you are going to make it once you enter into the contract, that is actually quite a significant risk potentially, both in terms of time and cost, because what if building safety regulator says, okay, I don't agree with this, or I think, this bit which you think is not a higher risk building, actually I count that as part of the higher risk building. So you might need to change the design. So I think having amendments in the contract to deal with that sort of thing, and any changes to the design necessitated by a building safety regulator saying, okay, well, I want this or I don't want that, I think that is probably a good idea, because if you're relying on the standard JCT clauses, they may or may not provide for that sort of scenario. I mean, do you think that's the case, Olivia?
I completely agree. I don't think I can add anything to that answer. Also, I've noticed we're slightly over time, unless you want to do more questions. But,
yeah, I think we've dealt with most of the questions. There's the only one question left, isn't it? Which is that's the extension of time provisions, and that the question asks as well. I've mentioned the 8-week timetable for the employer to give a decision. So on an EOT claim, so whether that when does that sort of start running from? So that's a simple answer. So if one goes actually to clause 2.2.5.2 of the design build contract, for example, you would see that the 8-week period runs from either the receipt of the particulars of the EOT claim itself, or it's from the date of the receipt of the further information requested under clause 2.24. So yes, if the employer requests further information, then that sort of pushes back the 8-week decision period. So to be fair to the employer, they would need time to at least receive the information and consider that. So that's a yes. I think short answer is yes to that question. It gets postponed if you get a request for information. So I think that's all the time we have this morning. Thank you very much for tuning in and for all the questions. Hopefully that's been helpful to all of you. As I said earlier, you will get a link to this webinar again, so you would get the full sort of webinar and the Q&A section if you want to revisit it, or if any other colleagues wants to look at this afterwards. But thanks very much for joining. I hope to see you at another webinar very soon.